In a moment, we'll give you analysis on that court challenge that has gotten underway in the High Court in the Western Cape and will continue until the 7th of August. But before we do that, there's something we want to show you as far as that act is concerned. It's called the Expropriation Act. It was signed into law by President Cyril Ramaphosa. Basically, what it does is it allows the state to seize land, not just land, property, land being one type of property that can be seized in terms of this land in the public interest and for a public purpose. That echoes throughout that act, and I'll tell you why. What the act tries to do is to try and make a linkage between our constitution as well as the act itself around issues of circumstances under which expropriation can happen in our country. So that language that you're saying in the public interest and for a public purpose is straight from Section 25 of the Constitution. In fact, what this act tries to do right at the start in its preamble, it recites Section 25 in its entirety, what it provides for the circumstances under which expropriation can happen in the country. So that's the first thing I wanted to highlight for you. The contentious thing has to do with Section 12 of that Act. Section 12 provides for instances where expropriation can happen and the compensation is determined to be the equivalent of a big fat zero. Basically, no compensation is due in that instance. There are certain specific instances where that can happen, where land is held by the owner, but it's not being used profitably for anything other than, for speculative purposes is one of them. Land held by the state itself, and that the state, an organ of state, doesn't intend to use for any particular purpose, but also land that has been abandoned are those instances that are cited. But as I say, it is the contentious bit, the really contentious bit as far as this act is concerned. Then let me show you a bit more about this act. The background and context of it all is some of the work that has to do with the country's land reform processes. And you will know that in the definition in the Constitution as well as in this act, they do say that the public interest includes the country's commitment to issues of land reform and redressing the imbalances of the past. Well, what do those look like? As far as land ownership is concerned, we know from the 2017 land audit that was done by government that 79% of the country's land is in private ownership and 14% is owned by the state. As far as what government has been able to do from around 1995 until now in terms of settling the claims for land restitution, they've done about 83,056, and there's still quite a number of claims that are yet to be settled, including, of course, the contentious issue of some 5,200 so-called old order claims that are yet to be settled. So let's show you another aspect of it. It's politically contentious, as you can imagine. In January 2025, President Cyril Ramaphosa signs the act into law after much debate. That's what we are in court about, but also shortly after that, the US president includes the Expropriation Act among the grievances that he has against South Africa, particularly offering South African Afrikaners refuge in the United States, alleging that measures such as the Expropriation Act amount to discrimination against them. And the response from Pretoria was emphatic, with President Cyril Ramaphosa insisting that South Africa will not be bullied in terms of the laws that it needs to pass. So let's tell you quickly then about the court cases that we are dealing with. We are foregrounding a lot the Democratic Alliance, but they are not alone. It is a consolidation of 3 cases, with the DA being one of those that are challenging the act. You will also throw in the AfriForum as well as the Institute for Race Relations. And there's some bits that become a bit technical. So let me try, as my last bit before we get to our interview, to try and explain. Section 19 talks to issues of mediation in circumstances where the organ of state wanting to expropriate and the person affected, can't find one another in terms of the price to be paid for that compensation. Then it can be resolved via mediation, but if that fails, then it can be determined by a court. That's one of the sections being challenged because, according to the DA at least, it clashes with an earlier section in the Act, Section 8, I believe subsection 3, which talks to, a notice of expropriation, that it must, in some instances, include the compensation as determined by a court. And then lastly, the National Council of Provinces is the other contentious aspect. And that has to do with whether or not, in terms of the voting that happened in the NCOP, remember the NCOP works in delegations of provinces, whether or not a number of those provinces, and in fact, I think the DA sets the number at about 7, whether those had the requisite mandates to be able to participate in the manner that they did in the voting that took place to pass this act in Parliament. So they are hoping to come home and dry on any of those grounds in challenging the act. So that's what that's looking like. Let me go back to the desk as we pick up on that conversation on the first day of arguments that has happened at the High Court in the Western Cape. And for that, we're joined now by the Director and Head of Land Reform at Werksmans Attorneys, Bulelwa Mabasa, joining us to pick up on that conversation. Good evening to you, Bulelwa, and thank you for your time. I hope I did a decent job in trying to outline what this dispute is all about. It's quite technical, but pick up for us, what's at stake here?
Look, I think the dispute that is currently sitting before the Western Cape is important in the broader expropriation debate. The main debate around expropriation has been around the question on whether or not the state can expropriate without compensation. What we do know is that expropriation has always been part of our law. What we do know is that we're currently sitting with the 1975 Expropriation Act, which has been in operation since time immemorial. We know that expropriation is an accepted concept that is applied throughout the world. And so the major debate that this court has to grapple with here is whether expropriation without compensation, as it is worded in the current act, falls within the Constitution. And the second issue that is, in my view, an issue that sits in the nub of the issue is whether or not the circumstances that have been said to be those that allow expropriation to happen without compensation, whether the way that they are worded is a closed list or whether there is scope for the state to extend it. And then, of course, lastly, is this issue around whether expropriation, the state can continue with the process of expropriation while parties are trying to resolve it via mediation and arbitration. So as much as this issue is framed as a political one, I think it's important to bring the issues quite squarely within what the court is grappling with from a purely legal perspective.
So that's interesting the way you're framing it, Bulelwa. There's the question of, some, especially when they speak about it glibly, in politics, they say this is expropriation without compensation, akin to the kind of debate we had a few years ago when there was the attempt to amend the Constitution to provide specifically for expropriation without compensation. But those who support the Act simply say that's not what this seeks to do. This seeks to continue along the theme of just and equitable compensation for expropriation, with a few exceptions where compensation can be calculated to be nil. Is there a fundamental difference between nil compensation, expropriation without compensation, in terms of the concept, the broader concept, in terms of what we had envisaged a few years ago and what we are seeing now?
So there's a fundamental difference about what happened a few years ago. A few years ago, when we had the national process, when there was public commentary around whether the Constitution needed to be amended or not, we know that that process did not succeed. And the argument then was that we need to amend our Constitution in order to make room for expropriation without compensation. At the time, one argument was we don't need to amend the Constitution because the Constitution already gives us guidelines that we need to take into account when we're calculating just and equitable compensation. This process now that we are seeing is a different process that is not linked at all with the amendment of the Constitution. What this does is, as I said in the introduction, we've got the Expropriation Act of 1975, which has somewhat become outdated. The 1975 Act predates the Constitution of 1996. And for all these years, we hadn't brought the Expropriation Act along with what is envisaged in the Constitution. The 1975 Act made provision for market value compensation. What the Constitution envisaged was something different, which is just and equitable compensation, which is a specific formulation that if you apply that formulation in Section 25.3, you may end up with compensation that is above market value or even below market value or nothing. So it's a fact-based system that is envisaged in the Constitution when you have to apply those factors in Section 25.3, which are what is the current use of the property, what is the current market value, has there been any state investment in the property, and what was the historical acquisition in the property. So in other words, what this act is, at least if you count from 1975 until now, that's how late it is. And if you count from when the Constitution was promulgated in 1996, it's at least 30 years too late.
Right.
But
Bulelwa,
what this does...
I'm sorry, Bulelwa, I do want to give you one final take before I wrap up. I'm almost out of time. Of the arguments that were presented by the various parties in their papers, as well as on day one of the arguments around Section 19 of that Act, around mediation and including in the notice, the amount determined by the court. Between that argument and the arguments about public participation as represented by the processes followed in the National Council of Provinces, which ones, and I'm not asking you to judge the matter, but which ones do you weigh to be they're going to be decisive in this battle?
Look, I think the wording of including but limited to, when it comes to the circumstances that can lead to zero compensation, that wording could be made more certain, it could be made clearer. I do think that the court does sit it sits with the various arguments around how to neaten or how to neutralize the potential confusion that comes with when ultimately the expropriation process could take place. I think all those, the reading in process that the courts are empowered to implement could assist the court. In terms of the balance of the Act, I think it is trite that we do need this Expropriation Act in terms of the Constitution. It is also trite that it can only happen by way of just and equitable compensation. The issues around reading in and all of that, I think that's what the court will assist with, and hopefully it won't need it to go to the higher court, such as the Constitutional Court, before there is real certainty around it.
All right, let's see how it all unfolds. We thank you for your time and for sharing with us some of your insights. That's Director and Head of Land Reform at Werksmans Attorneys, Bulelwa Mabasa, weighing in on that court case that has now started.